All right, guys, so now the question arises, what will the Supreme Court do next? Because overturning Roe versus Wade, a precedent since the 1970s, is coming as a shock to many people, and they're worried about, well, what other things are potentially on the chopping block. So Mark Joseph Stern says the following: Alito's draft opinion explicitly criticizes Lawrence versus Texas, which legalized sodomy, and Obergefell versus Hodges, which legalized same-sex marriage. He says that, like abortion, these decisions protect phony rights that are not, quote, deeply rooted in history. So I need to correct him here, because he says the draft opinion explicitly criticizes these cases. It doesn't. It actually implicitly criticizes these cases, at least based off the little excerpt he has here. So let me read this to you. These attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Then he cites Casey and says, those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. All right, so let me pause on that for a second. He's saying, look, if you take the current interpretation of the expansive list of rights you have under the Constitution, that would mean you also would have a right to drug use, because you could put in your body whatever you want to put in your body as long as you're not hurting anybody else. And you also would have a right to, say, prostitution. To which I respond, that is correct. That is correct. I agree with that. I do think you have a right to those things. I think the state getting involved in your private life, in your social life, to that extent is way too big of government. It's way too authoritarian a government. And on social issues, I think most Americans have the default feeling of live and let live. Now, I'm sure there are, nuances to that and caveats to that and little points of disagreement, but by and large, I think most people do fall under that category of live and let live. Why should the government have any right to determine what I put in my body or don't put in my body? Why the hell should they be able to lock me in a cage for years over some sort of drug use? So when he points this out, he's trying to make this point to slap down the current interpretation that we have of the Constitution, that you actually have these expansive rights. But really, I just think he ends up strengthening that case, like the living document case of the Constitution. And then he continues and says, see Compassion in Dying versus Washington. I guess that's a euthanasia case. He says, none of these rights has any claim to being deeply rooted in history. Okay, so that is the implicit criticism of gay marriage being a constitutional right. That's the implicit criticism of, having a right to sodomy, for example. That's honestly an implicit criticism to the idea of interracial marriage. Because the argument from social conservatives is, look, you cannot interpret the Constitution through a modern lens. You have to interpret it as it was written and nothing else. So their argument is very straightforward. I mean, they say, look, Thomas Jefferson and James Madison and the founders, they didn't put a right to gay marriage in the Constitution, or they would have said, you have a right to gay marriage in the Constitution. They didn't put a right to interracial marriage in the Constitution. Interracial marriage was banned at the time. They didn't put a right to sodomy in the Constitution. Sodomy, in many instances, was banned at the time. So since it doesn't say, in very explicit terms, that these things are allowed, well, we're going to say you don't have a right to them. And that if states want to legislate against your right to a blowjob or anal sex, against your right to interracial marriage, against your right to gay marriage, against your right to an abortion, well, they can legislate that. See, look at their idea, their conception, their philosophy of the Constitution, taken to its logical conclusion, actually is an argument for a giant authoritarian government that nitpicks at your social life. Whereas, of course, there's a number of ways you can interpret the Constitution in a broad sense to protect these rights. Equal protection under the law. There's a good argument for equal protection under the law would mean that, the government should have no right to say a gay person can't get married to their lover. But they say no, since it doesn't explicitly say that gay people can get married, and you have to do a little leap of logic to get there, it shouldn't be allowed. So he really is implicitly criticizing gay marriage, interracial marriage, Euthanasia is another one, which is physician-assisted suicide. It's barely masked. Sodomy, if some states would go back to making sodomy illegal. So this is draconian, it's primitive, it is deeply socially conservative, and most importantly, it's authoritarian. It's this idea of being super literal with the Constitution and not using logic, not using reason, not allowing in modernity. So what is next on the chopping block? I don't know, man. Your guess is as good as mine, but will there be some case that challenges sodomy or challenges same-sex marriage? You betcha. You betcha. At the very least, they're going to challenge same-sex marriage again. So, buckle up, man. Buckle up. So now, let me show you this. The last time the Supreme Court played a judicially activist, politically conservative role was the Lochner era. Minimum wage and child labor laws were struck down as unconstitutional. So this is something I remember learning about when I was getting my degree in political science. And I remember being fascinated by this. Let me read you a little bit from the Wikipedia here. Lochner era. The Lochner era is a period in American legal history from 1897 to 1937 in which the Supreme Court of the United States is said to have made it a common practice to, quote, strike down economic regulations adopted by a state based on the court's own notions of the most appropriate means for the state to implement its considered policies. The court did this by using its interpretation of substantive due process to strike down laws to be infringing on economic liberty or private contract rights. So let me flesh that out a little bit for you. What that means is they argued a business owner has a right to contract with their employee. So they can set the terms of the agreement, of the relationship, of the employment, and the federal government has no right to step in and lay out some basic ground rules. Like, hey, you have to do some overtime pay. You can't overwork these people. You have to have safety regulations. If you're doing some construction or something, you need to wear a helmet. You need to offer, X amount as a minimum wage. You can't pay them less than that because that's exploitative. The Supreme Court decided all federal regulations that would get in between an employer and their employee is a violation of what they called a right to contract. So again, this here was viewed as judicially activist, but politically conservative. So this is something you hear all the time from the right. They say, oh, we hate these judicial activists on the left, where they legislate from the bench. Well, this was legislating from the bench from a right-wing perspective. So let me give you more. They say the Supreme Court during the Lochner era has been described as playing a judicially activist but politically conservative role. The court sometimes invalidated state and federal legislation that inhibited business or otherwise limited the free market, including minimum wage laws, federal but not state, child labor laws, regulations of banking, insurance, and transportation industries. The Lochner era ended when the court's tendency to invalidate labor and market regulations came into direct conflict with Congress's regulatory efforts in the New Deal. So yet again, saved by FDR, but has been eroded over time. So, are we entering a new Lochner era? I mean, clearly this decision on Roe is the beginning of a dangerous new era, to say the least. Let me show you one more thing, because this is actually a wonderful point here. Internet Hippo, who I love, by the way, said, you know what else isn't in the Constitution? The best known power of the Supreme Court is judicial review, or the ability of the court to declare a legislative or executive act in violation of the Constitution. It is not found within the text of the Constitution itself. The court established this doctrine in the case of Marbury versus Madison in 1803. Ain't that something? So the whole notion of like literalism or originalism, this whole idea that you have to interpret the Constitution as strictly as possible as the founders intended. If you do that, you wouldn't even be in favor of judicial review. You wouldn't even be in favor of the Supreme Court to override or overrule a legislative action or executive branch action, because that is not explicitly laid out in the Constitution. It is interpreted from the text of the Constitution. There is a leap there, in the same way that there's a leap in terms of bestowing the rights to gay marriage and interracial marriage and the right to an abortion. So they're in favor of some leaps of logic, but they're not in favor of other leaps of logic. Really, at the core of it is their politics. Now, they would deny that up and down, but they're fucking wrong. At the core of it is what their political views are. So, what's coming next from the Supreme Court? I don't know. I do not know. I don't have a crystal ball. I do have one crystal ball, but I don't have the one that can allow me to read the future. I guess we'll find out together, but if there's not drastic changes, a lot of the social progress that has been made over decades could be eroded and could be reversed, as we've seen with Roe v. Wade. And again, there will be a backlash to this, because one poll has 70% of the country is against overturning Roe versus Wade. I've seen polls as low as 58, as high as 70%. Only 19% of the country thinks that abortion should be, quote, illegal in all circumstances. That's the least popular position on abortion. And that's the side that just won. Now, states are going to have the ability to totally ban abortion, and at least 20 of them will do exactly that. So, we'll see what else they roll back, but it might not be pretty. And by the way, one more point on this. The Democrats, multiple Democratic presidents over the years, from Jimmy Carter and onward, have said, well, I'm gonna codify Roe versus Wade into law. So in other words, we'll pass it as legislation through the House and the Senate, and then I, as president, will sign it. They all said they were going to do it. None of them did it. Many of them had supermajorities, and they didn't do it. Obama could have done it. He said he was going to do it. He didn't do it. If we had that right now, well, then Roe would effectively be protected, at least until there's a Republican supermajority where they could get rid of it. Okay? But it would be protected more so if you pass it into law. They said they were going to do it. They didn't do it. So yet again, unfortunately, the fecklessness and the weakness and the pathetic nature of the establishment Democrats has also helped lead us to where we are now. And it's a goddamn shame. So now we're actively, instead of stagnating or stalling with the arc of history bending towards justice, we're actually moving in the opposite direction, which again is going to have consequences. It's going to lead to a backlash, and we'll see what other damage the court does, but it could get ugly.